Dean of the College of Arts and Sciences at Tennessee State University, and the topic is African Americans and the Constitution. And of course, Dr. Lovett, during the first two segments, we've talked about some aspects of the African American experience, historical experience. But let's allow you the last 5 or 6 minutes that we have here to sort of summarize, not only summarize, but also to introduce some additional information about African Americans and the Constitution after the Civil War period. Let's do it from that perspective.
Well, one of the things that has always preoccupied this country has been the issues of race and class. And those issues have always been constitutional and legal issues. There are many books that people could read on the Constitution and slavery, some excellent books. And there are other books that have been done by constitutional historians and legal scholars, because those two issues have always been the center of many court battles, and they still are today. Affirmative action is an example. And so we have never, since the days of slavery, gotten away from the court trying to mediate race and class conflicts in American society. But in 1865, the Constitution was amended, the 13th Amendment, on December the 18th, 1865, ratified by the states, which outlawed slavery forever. That was one of the best amendments for African Americans. Slavery is no longer legal anywhere in the country. And in 1868, the 14th Amendment was added to the Constitution, which it provided citizenship, equal protection, and due process of the laws for former slaves or anybody regardless of race, religion, and so on. And then 2 years later, in 1870, the 15th Amendment was added, which guaranteed the right to vote to all persons regardless of previous condition of servitude, race, or whatever. And in fact, African Americans had been voting since 1867 because the Reconstruction Acts passed by the Congress provided for their vote. And by 1868, they were the majority of voters in the South. And that allowed them to hold office as well. And so 22 African Americans served in the Congress until 1905.
This is in Washington, D.C.
Right, until the last of them left, George White of North Carolina, in 1905. And no African Americans were returned to Congress until the 1960s because of the laws that southern states put in place to disenfranchise African Americans. Much like the constitutional laws that are being put into place in southern states now. For example, in Alabama, 1/3 of African American men cannot vote in Alabama. And they cannot vote in Alabama in 1998, 99 because of the convict laws. That is, if they have been felons or whatever, they are disenfranchised forever in the state of Alabama. And so 1/3 of African Americans even today are suffering, men, what they suffered back in the 1890s when they were subject to poll taxes and literacy tax tests and all those things to take away the vote from people of color. But the Constitution has always been sort of used to try to decide racial issues in our society because it's such a racially divided, society. Then and as it is now. And of course, as you know, the fight is over affirmative action and all the other things, but they're the same issues.
But these are all constitutional problems.
Right. The issues is who's going to dominate the society, who's going to participate in it, and who's not going to participate in it. Who's going to be black, and those are citizens with limited privileges. That's what the word black means. And who's going to be white? Those are citizens with all of the privileges. That's what white means. Otherwise, there's no such thing as a white race or a black race. They're African Americans, European Americans, or Asian Americans, or whatever. But we're the only country that has a definition that deals with race. And that particular definition means that there's a dividing line. That's all that black-white means. And the Supreme Court has always, since slavery, been in the middle of that, trying to mediate those issues. How much do we give this side, and how much do we let them go forward, and how much does this side get to keep them from going too far forward? That's basically what the constitutional issues are about. Many of these particular things will be discussed as far as Nashville is concerned in my new book, which was being published by the University of Arkansas Press. And that book will be appearing in May of 1999. It's entitled African American History of Nashville from 1780 to 1930, Elites and Dilemmas. And for example, by 1867, Nashville has 5 black city councilmen. that are serving in the city council. It has...
this is right after the war.
Right after the war. The first African American to be elected to the Tennessee General Assembly is from Davidson County, Sampson W. Cable. By 1881, there's a second African American elected from this county to the General Assembly. And across the state of Tennessee, especially in West Tennessee, where 70% of former slaves lived and still live today, about 69 or 70% live in West Tennessee. There were even more African Americans who served in city councils, county commissions, as well as the state legislature. And then, of course, there were laws put in place to disenfranchise them. And by 1900, there are no African Americans serving on the city council of Nashville or serving in the state General Assembly of Tennessee. And in some ways, in Alabama, Mississippi, and Georgia, just through the convict laws alone, we're moving back toward that way. And that is, we can use convict laws to disenfranchise them again, because you can't use other means because of the 1965 Voting Rights Act, and because of the 24th Amendment to the Constitution, we can use convict laws to take away their right to vote.
You know, Dr. Lovett, let me thank you for coming by and giving us that excellent information. And let me also encourage our audience to tune in again next week for another informative edition of Comments. Thank you and good morning.